Okay. Okay, we're live. uh, Hello, my name is Bryn Nelson, and I am coming to you from Seattle, Washington. Welcome to our third uh, virtual mentoring session, and we have Emily Gertz as our technical engineer in Brooklyn, and I'm pleased to introduce Mark Schrope, who is our virtual mentor, who's coming to you from Florida. And Mark has been a freelance writer and editor since the turn of the century, which is to say that his neighbors wonder what he's doing there all day. Based in Florida, his work has taken him on a flight into the eye of a hurricane, to the sea floor by submersible, and around the world, from a remote Colombian island to the coral reefs of Indonesia to the deserts of Egypt. Though many articles focus on the ocean, he covers a broad range of topics under the general headings of science, technology, and travel for publications such as Nature, The Washington Post, and Sport Diver. Mark is also our resident advisor on contracts, which is the topic of today's virtual mentoring session. But first, wanted to start by asking Mark how you became a science writer.
Okay, hi there. So I started out with a background in oceanography and worked for a few years at that, but that was a long time ago, and I guess it was '98 that I left. I liked research, I liked oceanography, but like a lot of science writers will say, I didn't really have the attention span to spend years or decades on the same thing, and was just really attracted to writing, had always thought about that, and learned about the UC Santa Cruz program. So in '98, I left a job as an oceanographer in Virginia, moved to California with my family for a year, and went straight from that into full-time freelance writing, and have been doing that ever since, with a period of about 3 or 4 years where I continued freelancing for magazines, but also worked as a writer for a place called the Harbor Branch Oceanographic Institution. And now last time I checked, probably about half of what I do is magazine writing, and the other half is more contract type work for universities and nonprofit organizations and that sort of thing.
Okay, great. So I think to start us off, maybe you could talk a little bit about what was your worst contract, and you can withhold the guilty parties' identifications. But just as a concrete example, to say how you were able to get a bad contract fixed.
Right. Well, the one that I have in mind is pretty typical of what's happened, and you'll hear when you talk to other writers, you'll hear the same thing a lot. It was a publication. In this case, it was a publication with an online presence, like I guess everybody has now. But in the early days, when I first started writing for them, they had a fine, fairly standard contract. I found that things got a lot worse. Got a lot worse over the past, say, 10 years or so. There was a big decline. And so this was a publication that I'd written for under a good contract. Hadn't done anything for them for a couple of years. They came to me and asked me to do something again, and the contract during those couple of years had just gone to becoming sort of a case study in all the things we tend to point to as the things to avoid, the things we talk about in the chapter. There was an awful indemnity clause that was the type that meant that I had to say that any problem, even a lawsuit arising from no mistake of mine, that I had to pay for everything, and absolutely all rights were owned by the publication, so they could do whatever they wanted with my story for very little pay, I might add. And so, as is typically the case, I started out by shooting a quick note to the editor. It's rarely the editor that handles these sorts of things, and in that case, sometimes you go back and forth. In this case, I ended up talking directly to a contracts administrator person, and that was the reason it sticks out as a worst case scenario, is because she was just very sort of, I guess, condescending, even acted like it was ridiculous that I had any questions about these contracts, said that nobody else had raised any of these issues, which is sometimes the case, but I've also heard confirmation from people that that's said a lot when it's not the case. But at any rate, we went back and forth. I tried to be polite, and we ended a phone conversation with no real agreement, but by email we were ultimately able to make a few of the types of changes that I outline in the chapter, and that organizations like ASJA and others have recommended, that are not, certainly didn't turn it into an ideal freelance writer's contract, but
Oh, you're back.
okay. I'm not sure.
Sorry,
what
folks.
Anyway,
just had
I
a
had just
technical glitch, but you're back.
That was
Okay.
pretty good timing. So that was the end of it. Yeah,
Okay.
so I did get some changes made. Not everything that I would like, but it's a good point, because even, I mean, that was the only time in my career that I can remember any kind of situation like that that seemed almost hostile. And when I hung up the conversation, I thought, I'm going to have to decide, am I going to write under a bad contract, or am I going to stick to my guns and not write? I didn't think there was any way that we were going to come to an agreement. And even in that case, we came to some agreements. So there is hope.
And you mentioned a little bit that I guess partly because you're more aware of these now, that you're seeing more. But in terms of hearing from other people, does this seem to be an increasing trend, that you are seeing contracts with unacceptable indemnity clauses, for example, or ones that are wanting to retain all rights, in perpetuity? I mean, we've seen some of those with some web-based organizations, for example. What's your sense of the trend?
It is absolutely a trend towards what I mean, obviously there's two sides to this. I think that writers can make some very good arguments, and we try to make good arguments about why it's not just an us versus them. It's just sort of a matter of basic justice or fairness. But there's definitely a trend towards, we'll say, contracts that very much favor the publications at the expense of the freelance writers' rights. I mean, I've got the contracts. I keep, all the publications I've written for, I keep all my contracts. And when I was, just to kind of confirm this in my own mind, when I was working on the chapter, I went back through, and time and again, I had early contracts from around the 2000 range that were not too bad. And then more recent contracts that were just what we would consider awful, and the lawyer that I worked with also confirmed that, and editors have as well. That I mean, it's definitely the trend is away from freelance friendliness, and I'm sure we'll get into some of that here today. But a lot of that is because for years writers weren't speaking up that much. So if it was just one or two people complaining, why not make the contract that is very much favorable to the publication? But that's changing. We've got examples of that changing, and hopefully that will continue to change.
Okay, great. And just a quick note, the chapter that Mark is referring to is this book, and I'm just going to do a quick product placement, but this is the Science Writer's Handbook, and Mark wrote the chapter on contract literacy. So again, some of we'll be talking about other things as well, or expanding on the chapter, but that gives a very good grounding in some of the issues that we'll be talking about. And one of the ones that seems to be kind of among the worst, or the ones that we hear about a lot, are indemnity clauses. And I'm wondering if you could just kind of explain kind of what an indemnity clause is, and what makes an indemnity clause a bad indemnity clause.
Right. So in simplest terms, the indemnity clause is the part of the contract that determines what happens if we all get sued over an article. And the trend has been very much towards language, and it's hard sometimes to follow this language if you're not a lawyer. And I should say a disclaimer here, I'm definitely not a lawyer. This is not official legal advice, anything I'm going to say. It's more just descriptions of my own experiences. If you get into serious issues, you may want to talk to a lawyer someday, or somebody like that. But at any rate, it's hard to follow the language. But what they say, essentially, the bad indemnity clauses are, if we get sued for any reason at all, the writer, the writer, has to pay everything. That means if we ended up having a judgment against us, that's the writer's responsibility to pay that. Legal fees for the publication, even a massive organization, a massive commercial entity, we're supposed to pay their legal fees, pay our own legal fees, and all of that. And the arguments they'll make, which there's reasons against this as well, but the starting point is, well, we're just...
Oh, sorry, folks. Another little Google glitch. Mark should be rejoining us momentarily. We're just a little there. There he is. Mark is back. There you go. You're back.
Back?
You're back.
Great. That one wasn't such a good stopping point. So, yeah. So the starting point is, we're just asking you to stand behind your work. But it's about much more than standing behind your work, because there are plenty of scenarios you can think of where somebody might bring, for instance, a frivolous lawsuit. You haven't done anything wrong as a writer, but either, I guess you could imagine even ending in court, but what's much easier to imagine is that a publication would settle out of a court for, say $100,000, just because it's going to be too much of a nuisance to fight it. And then technically you're on the hook for that, even though you haven't done anything wrong. And, there's wider issues here about how much money they could actually get from the average freelance writer, and that sort of thing. But that's the main issue, is indemnity clauses that dump everything on the writer, and that's what we want to avoid.
Right. Okay. So let's talk a little bit about, there are a number of different ways that you can go about addressing that. One is to ask the publication to strike the indemnity clause altogether. But there's also, I guess, some wording that you can put in. I want to ask you to give us the exact wording from memory. But if you could give us kind of like the spirit of this is what you should be asking for to make it a little bit more reasonable and fair. Oh, we seem to have one more glitch here. And let's see if we can get Mark back. There we go. Okay. Hang on one second, Mark. We're not able to hear you. There you go. Okay, and now you're back. So sorry everyone. Google Plus is throwing us a few curveballs, but Mark is back. Yeah. And the question was on trying to rectify bad indemnity clauses.
Right. So there's two real key places. One is they'll say they'll ask you to say that what you write is not going to be libelous, et cetera, et cetera. It's not going to offend anybody. It's not going to break any laws. And one of the key points is, especially in a global marketplace, everything we write is available worldwide on the internet. You can't say that because we can't possibly be familiar with the laws in every country where this will show up. So you can add language that says things.
And sorry, folks. I think Google is experiencing some technical difficulties. That's why Mark has been sort of booted off occasionally by Google. He will be rejoining us shortly. Again, hopefully, there seems to be a congestion issue on Google's end. So let's hang tight with me. Sorry for the issues, but he was in the middle of talking about indemnity clauses. And during this break, my producer is telling me to remind you to tweet your questions to hashtag SciWrite. That's SciWrite. And Mark will be handling your questions just as soon as Google Plus allows him back on the Hangout. And here he is. Back on. There we go. So sorry, Mark.
Not sure what's going on.
That's I think it's a Google Plus congestion problem. So not on your end.
Fun
but
with
anyway,
computers.
yes.
Okay.
So you were talking to us about changing a bad indemnity clause.
Right. So yeah. So that first thing is you can try to add to the best of writer's knowledge, so that there's at least some protection there against something that you have no way of knowing. And then the big one is, I should say, I mean, I always suggest to be helpful that we can just drop the indemnity clause. That rarely, there have been times when that has worked. It rarely works. Usually the best you're going to do, because there's usually some lawyer down the road somewhere, down in the chain somewhere, a lawyer that you won't talk to who is feeding information back to an administrator or an editor and saying, no, no, no. So what will work a lot of times is to add language along the lines of, you kind of tack onto the end that.
Oh, and right as he was getting to the meat of the answer, Google Plus boots him out. And Mark was just talking about the phrase of what you can add back to the end of the clause. And here is Mark again to tell us.
Talk more quickly.
I know.
So
yeah. The phrase. I'm sorry. That you were saying the phrase that you add to the end of the clause.
Yeah, I actually pulled it up. You say something like, provided that such liability is finally established by a court of competent jurisdiction and that such judgment is sustained after all appeals have been exhausted. And that's lawyer language for saying, okay, if I'm going to pay, it's going to be only after a court of law proves that I did something wrong. And that's how you avoid things like a frivolous lawsuit that somebody might want to settle out of court or something like that. Where you haven't done anything wrong. And I have to add, as frustrating as these things are, and as much as we do get hung up on them, and I think for good reason, that it's really worth working on these things, the likelihood that this is going to play out, that there's going to be a lawsuit tied to your article, particularly for us that write mainly about science and those things, the chances are very slim. You don't want to take those slim chances that you might be on the hook for tens or hundreds of thousands of dollars, but it's very slim. So I don't really think we need to stay up, lose sleep at night over these, but it's worth working on.
Right. Okay. Another question that often comes up when dealing with contracts is the rights of the writer. And so a question from Kate, one of our viewers, is that when a contract says that you can't write about a particular topic for another publication, how narrow or broad is that generally? Oh, and again, Google Plus is foiling us, and there you go. Are you back with us? And one second while we get the sound.
Yes.
Okay, there you go. There you go.
So, I mean, the short answer is not going to be that satisfying, which is it just depends on the contract. They're all different, and there will be some language describing how how strict, how tightly bound that sort of non-compete clause is going to be. Remember that everything is negotiable, or at least potentially negotiable. The amount of time that you're not allowed to write about that topic is something you can say. Most of this stuff is boilerplate. It's typically you might come and say, look, I can't go 90 days. I'll give you 30 days. And you can also look carefully at the language and think through what that says about how broad that non-compete is, and you might throw something in to make it more specific, to make it better match the topic that you've written about, so that it doesn't so broadly eliminate you from writing about other related things.
Right. Now, along with that, there's also the rights of the writer in terms of like who owns your content in perpetuity. And so there are examples of writer-friendly contracts where the publication may have, for example, first North American rights, or that the rights may revert to the writer after a period of days. And so I'm wondering if you could kind of talk about just in general terms from kind of best to worst as to these types of contracts, and if there's anything that can be done to give you more of your own rights to your words.
Yeah, so this is another area that most writers who are paying attention to these issues take very seriously. It's another area where we've had major erosion. The trend has been to go towards contracts that are either all rights or work made for hire. And what that means, again, in simplest terms, is that the publication pays you a fee for what you write, and that's it. You have absolutely no say in what they do from there. They can sell that story to as many other publications, use it in as many other ways as they want, and you have absolutely no say to that. And more importantly, you don't get a cut of anything that they might make off of that. And so this is an area, I mean, so that general trend to not pay us anything. So we've had the fees that we get paid have pretty much been declining, or at best staying level, more often declining over the past several years. And then on top of that, you have this situation where any chance of making additional money, in many cases, not all cases, has been taken away. So that's a really important area to look at. And here, unlike the indemnity, where you're dealing with something that is a very slim chance, this is very real stuff. This affects your bottom line. And so lots of people, myself included, would always try to change a work made for hire or an all rights contract to get something that's more limited. There's a few different areas. I won't go into all the specifics. I can answer questions if people have questions. Some of that's a lot of that is covered in the chapter. But in general, what you'd like to get is the right to get a chunk of money if they resell somewhere else, or in some cases, large publications, if they have foreign editions, they might pay you another chunk of money. That's a really good thing. And then the other key issue is when the rights revert to you, which is to say when you might have the right to resell the story yourself and make some more money. Now, it's important. I'm not going to get into the specific language, but there's two ways that kind of thing can be handled. It can either be handled in a way where the contract says either one of us can resell it and make the money. That's not very good, because in almost every case, if somebody goes looking for the rights to republish your story, they're going to go to the publication. So if the publication gets all of that, then you're out of luck. And I've had contracts where that was the case. So what you like to see is something where they say, all right, for the first 60 days, let's say, we're paying you this money, we get to do what we want with it in our publication and elsewhere for 60 days. After that point, we'll pay you 25% or 50% of any additional fees. That's just a hypothetical, but that's the other way. But in all these cases, you're going to have sometimes where the publication is just absolutely dead set against it. They're like, this is our contract, you take it or leave it, and you have to make that decision. Do I want to stand on principle and say I'm not going to write this article because this is not really good language in your contract, or or you're going to go ahead and sort of suck it up and say, well, this kind of stinks, but I want to write this article, so I'm.
And we've lost Mark again momentarily. Sorry, folks. This is just a periodic glitch on Google+. But Mark was just finishing his answer and saying that sometimes you have to make the decision about whether you're going to suck it up and write anyway. And I just wanted to follow up on that and ask you a follow-up question, Mark. And I guess one of the things that that you've mentioned in the past is also that you can sometimes use a bad contract as leverage for more money if you can lay out the ways in which this is not benefiting you as a writer and say, hey, is there, given this, is there any way that you can come up in your fee? So if this is a work made for hire, I have no rights, things like that.
Yeah.
Is there anything that you can do to make it more, otherwise, can you make it more writer friendly? And I'm wondering if you've had success with that.
I can't remember whether I specifically have, but it's certainly and I've heard of plenty of others that do this, and it's certainly a reasonable position to take. You can say, look, what you're offering me is either a low fee or a sort of, on par with others' fee, but you're grabbing a lot more rights, and so your contract is worse. And so if you want the right to do all these things without giving me...
Oh, sorry, folks. Just bear with us. This has been happening periodically this hour. Mark is there. He is back. Just a momentary glitch, and this is just a congestion issue on Google. So, fortunately, he's popped back pretty quickly. So, sorry, Mark.
Back really quickly, so we can consider these pauses. But yeah, so you can take that position and say, look, if you want all these rights, you need to up the fee. If you're not willing to renegotiate some of these contracts that are not in my favor, then you need to increase the fee to make up for that. You need to pay for the rights that you want, and that's one of the ways to look at it.
Right. And in some cases, it can be worth asking a publication, I would imagine, if they have a second contract, right? I mean, aren't there ones where they actually have a better version of the contract?
Yeah, I mean, certainly don't expect this to be the case in a whole lot of places, but I jokingly talk about it as a magic.
And of course, apparently Google didn't like the joke because they have now kicked the joke. There's Mark back again. So sorry, folks. Right in the middle of your joke, Google Plus kicked you off. So you were saying.
So we call it a magic question to fix a lot of your contract issues, which is to just ask, do you have a better contract? I mean, you don't want to put it in a snide way, but you can pick something specific and you can say, this is, I have a real problem with all rights contracts or work made for hire contracts. Do you have another contract? Do you happen to have another contract that's a little more writer friendly, that doesn't grab so many rights? And there are, certain places where that's the case, and you ask for it, and they'll give it to you.
Okay.
Again, don't count on that. There have been more than one example of publications where I've had that experience, and people that I've spoken to have had that experience.
Right. And along the same note of making sure that you're kind of striking the right tone, that it's not too snide, I'm wondering if you can talk a little bit about kind of, how you can approach editors, because I think it's important to reiterate that editors are, a lot of times our friends in this. They're not the ones who are writing the language for these contracts, and a lot of times they can get the contracts changed if they know kind of what to ask for, from the legal team. So I'm wondering if kind of you have words of advice of how to strike the right tone and how to approach an editor who is in all likelihood on your side in this.
Right. Well, that's the key, and I've talked to a number of editors about this. So one of the problems coming into this is that it has been the case in the past, and I hope this is changing some, that sometimes it was the more obnoxious writers that took issue with portions of contracts. But the key, as you've already said, the starting point is just to remember your editor. There's no reason at all that this should be sort of an adversarial conversation with an editor. Your editor is your advocate. They're the ones that you're asking to go. They're not writing these contracts. They may not even be, especially until writers start asking questions, especially familiar with the contract, because it's not that's not their thing. That's not what they do. And so so that's the one thing, is to not at all act as if the editor is the person who has put this bad language in the contract. That's almost and probably never the case. And the other thing that I try to do when I'm starting out is I don't go into a big long explanation of the problems I have, because it may very well be that the editor is just going to have me start a conversation with somebody else. So you just say, look, to pick the easy examples, I have some issues with the indemnity clause. I have some issues with the rights. I'd be more than happy to explain that to you, but just let me know what's the process here. I'd like to request some changes. Who should I do that? Who should I have that conversation with? Something along those lines. And then, if the editor wants you, typically they'll say, go ahead and send a little explanation, and I'm going to forward that on to the lawyers or the contracts administrator or whoever. But the biggest thing is you're not going to, there's just no reason to make it a fight, as long as you're making reasonable requests. It just,
Right.
There's no reason for it not to be a friendly conversation.
Right. Right. One other question that we have from a viewer is whether have you ever encountered contracts that claim all of your writing, even writing that's off the clock, and is that enforceable at all?
I saw that. I assuming that must be somebody referring to a not a freelance position, but a more of a staff position, because you certainly couldn't ever do that in a freelance situation. Claim my writing outside of the bounds of a contract. And so this is not something that I know much about, but I would say that you would have to look at the language, and a lot of that stuff, again, is going to be boilerplate. If they hire an engineer, they don't want the engineer going off and designing car parts for another car company or whatever. It would just be a matter of coming to your supervisor, whoever, and saying, this doesn't work because I do some freelance writing on the side. So we need to change this language such that I can do my own projects like that on my own time, without that falling under the contract. But anything can be written into a contract, and anything can be, at least in theory, negotiated out.
Right, right. So in that case, it's more of working through potential conflicts of interest. For example, if you're an employee but doing freelance on the side, for example.
And it kind of goes to the obvious point for all of this stuff, whether it's freelance staff, whatever, is read the contracts. They're not much fun to read, but you've got to read them. And over time, you get used to the language, and it's not ever going to be light reading, but it starts to make sense. And if you stop and think through it, and you can check with other people to get a little help with that.
Right. So, so you said that that sometimes you just have to make the choice as to whether you're going to take an assignment if someone really refuses to change the contract. So, has it ever gotten to the point where you've had to either say no to a project, or you've been passed over on an assignment because you couldn't get a contract that you liked?
Thankfully, no, but in most cases, I've been willing to suck it up. And there's a couple of times, if I got a contract and kind of forgot to deal with it, and we're already well into the assignment, that's my fault. I'm not going to make a stink and say, well, I'm not going to file this with you until we fix this. That I'm going to suck it up and say, that was my fault. I should have dealt with this when I got the contract, and I didn't. But yeah, I got to say, I most of the time, it's a difficult decision to make, and it would have to be a major problem for me to turn down the assignment, because I'm a full-time freelance writer, and this is what I do to earn a living. Other people are in different situations, maybe, where they've got a little more freedom to pick and choose. But yeah, that's just a personal choice. There are definitely people that will, and it can also be a last straw sort of thing. You might have had other problems with the client already, and then you get into these contracts issued, and you say, that's it. There's too many red flags here. I'm goodbye. And you hope too. You want to be very polite, but very clear that this is a real problem, because even if you walk away and you never get to write for that publication because of that situation, hey, play it for Team Freelance, and maybe if they get that situation and a couple of other people starting to make a fuss about bad contract language, and maybe they start to listen.
Right, and that actually follows up to another really important point is kind of like the potential power of community here, and and a lot of people see this contract negotiation as sort of like a one-on-one negotiation, but in reality, it's possible that if you have a number of people that are all asking for the same things in a contract, are all saying, look, this is unacceptable language, I'm giving away all of my rights, or this is an indemnity clause that is putting the onus on me, that there is a possibility of having some sort of collective power to change that. And so I'm wondering what you think about that.
That's absolutely critical, and I really think I don't have any way to sort of check this for sure, but my sense is communication is increasing, and that's part of why we have seen some cases where publications are improving their contracts. It's much easier now. In our case, we have this group Silence of freelance writers, and we can go to that. There's lots of other groups. You can go to the list at places like the National Association of Science Writers. But the point is, and obviously this is more difficult earlier in your career, but particularly as your network expands and you get to know more people, when you go to write for a new publication, or if a publication you've been writing for comes up with a new contract, the absolute, if not essential, certainly the very best thing you can do is ask around and figure out what other people are doing and talk to them. Find out who has had success renegotiating a contract. I mean, I've done that numerous times, where you get to know, say, well, you'll hear from a friend or a colleague that I tried to renegotiate these, and this is what I was able to do, and this is where they told me there is absolutely no room to bend. And then you go into your negotiations knowing that, and it's just invaluable to get that information. And again, by having those conversations, you can also encourage more sort of more people to take these issues and look at them seriously. And if they know that other people are asking, they're going to be more inclined to ask. And I hope we
Right.
just didn't come up against like RICO laws or something by suggesting collective bargaining. I'm only
This is
suggesting collective thought or thinking,
collective advising.
not bargaining or anything.
Yes, and the disclaimer that we're not lawyers, and this is advice, or this is not legal advice. There you go.
No.
This is your advisor. So another question that has come through, and that's on something that you touched on earlier as well, which is the idea of being able to resell your work or not. And so is there a fair fee? And I would imagine this kind of varies from publication, but for a publication that is going to resell or reuse, especially to like an overseas publication, for example, what do you consider to be fair for
Right.
a standard article?
Yeah, I can't possibly put numbers on it because there's so many factors, but I can say the kinds of things that I would look at are, is this is it a large publication that seems to be well established in the country? You may or may not know that off the top of your head, depending on what publication and what country it's coming from. Or is this a tiny, unknown website? So depending on those factors, I mean, if it's a well-established publication that is a profit-generating commercial entity, I don't know. I would say you'd probably want to at least see 10% of your original fee, maybe more than that, depending on all those factors. If it's a very small publication, you might be willing to say, I would hesitate to ever do anything for free, just because that doesn't work very well. But you might look for some token fee, $50, $75, something like that. It's out of the blue. You get a check. The work is already done. That can be nice, and you don't have to look at it as what is it. When you take an assignment early on, it's what do I have to make in order to make this worth my time? But when you're reselling, you have a lot more freedom because you've already made those decisions. You've done the work. So anything can be good. But at the same time, you want to protect your rights. If it is a large publication, even in a foreign country, there's no reason why you shouldn't get a reasonably good fee for it.
Right. Okay. and sort of validating that what you're doing has value, has
Yeah.
worth. So once you sign a contract, what's your ability to potentially renegotiate a contract before the end of the term?
Well, I have to say, I mean, it depends. There's two kinds of contracts that you'll typically get. One is for a single article, whatever project you're working on, and then the other would be a blanket contract. A lot of publications will do that with their regular, or not even regular, but almost just anybody that they're going to take on as a freelance assignment. They'd rather go ahead and negotiate a long-term contract. If it's a single article or a single project, um, I mean, you can change anything that you're going to, that somebody will willingly renegotiate with you, but you don't have any sort of set rights there other than what's outlined in the initial contract for when you can terminate the
Right.
contract. If it's a blanket contract, then sure, at any time. I mean, I would suggest that you don't do it in the middle of an assignment. You do it, I would say, at the end of assignment. Say, hey, I was thinking, um, I've been writing for you a while. I'd like to talk about increasing the fee, or I've learned more about contracts. I have some concerns about this contract that I've already signed. I'd like to renegotiate that with you. Who do I talk to about that? But I would say in all these cases, you're not legally bound to this, but I would just say as a matter of, as staying reasonably easy to work with, that you want to do the negotiations when you're not in the middle of a particular project.
Right, right, okay. And and I would imagine too that also if the original scope of what was outlined in the contract changes, that may give you some more leverage. If it, in the middle of the project, the level of work falls beyond the scope, that also may give you a bit of leverage if you can successfully make that argument of saying we were this was just for editing, or this was just for writing, and now the expectations are dramatically bigger.
Yeah.
Um,
Well, and that's a good point. A lot of us, we're talking mainly about publications, but a lot of us, as I said at the beginning, I do a lot of contract work for universities and nonprofits and that kind of thing. Um, in those cases, you're typically going to have to come up with your own contract, or they may have a contract, but it's going to be very different than what you deal with the publication. And I should say too, personally, I don't have any concerns with work made for hire and that kind of thing if I'm writing for, say, a university client, because this is not something for me to go resell somewhere. This is something I'm writing for them for a particular project. But in response to what you were saying, it's good to work in some language in there, and it's not hard to do. It doesn't have to be all gobbledygook lawyerese, legalese. You can just put in there that this contract, the fee we're describing here includes writing the project and one round of edits or two rounds of edits. Any major changes to this, or you could be more broad and just say any significant changes to the scope of the work, because that happens a lot in those kinds of projects, will have to be renegotiated. And you sort of give yourself that protection that allows you to come in and say, all right, look, you decided that this was going to go out for review to 12 different scientists after I signed the original agreement. It's going to mean hours of work for me editing. We need to renegotiate that. We need to work in an additional fee there. But it's good to think about those things up front.
right. No, I think that's a critical point. As what happens once you turn in your first draft? Then what are your responsibilities? And
Right.
yeah, and if you have multiple rounds of editing that you didn't count on, that may give you more leverage to renegotiate.
Right.
So a question on, so when you're kind of setting your own contract and your fees for different things, because that's another, a question of being fair with the fees that you're asking for, but also sort of acknowledging kind of like the shifting landscape in terms of photojournalism, a video package. So do you ask to be paid at different rates for, if you have multiple elements and saying, okay, this is these are the words. I'm also going to give you, 4 or 5 photos if it's part of a feature story. For those that do, video work as well, or how do you deal with that when you're negotiating?
Well, I would say, as a general rule, again, the trend is toward the negative. People want to do all this extra stuff. They want to add video and photos, and we want to be multimedia, but they don't want to pay for it. There's all sorts of examples, of course, where people try to get writing without paying or not paying much and stuff. So I would say, as a general rule, absolutely. If they want something, so if there's a fairly well-established fee for writing, and they also want you to do some video, they also want you to take some photos, then absolutely those should be paid for separately with some kind of fee. That said, there's been plenty of instances where I have felt, to be honest, there's one online publication I've written for where it is an express part of my job to get the photography, and I usually do that through a scientist that I'm writing about, or I go to one of the stock companies. If I know there's no photography budget, I have a photo on my computer that I took, and it's easier to pull that down than to search through a stock. That's a rare example, but the point is, absolutely, there's times when I break the rules, and the thing to consider is whether the reasons why they're not paying you are reasonable. And there are different. Some people would say absolutely you should never ever do anything without getting paid extra, and that's there are good arguments to be made for that. But others will want to look at it. But I would say, again, as a general rule, absolutely, if you're doing more work beyond the standard writing, you ought to be paid more.
Okay. And again, I guess this goes back to your personal decision of what are you getting out of it. Are you getting increasing notice, or is this something that's going to help you build your brand? So in some cases, depending on the publication, maybe it's worth it to add that in. But yes, I think it's a great point of your work has value, so ask for it, because they'll say yes or no, but at least you've asked for it. So are there other potentially problematic parts of contract language that you've come across that maybe fall below the radar that people should be paying more attention to beyond indemnity clauses? And I guess we've talked a little bit about rights that writers have to their work. Are there other issues that you've come across or heard from other people?
Those are certainly the two issues that cause me and most people the greatest concern. Other things, it really depends, on sort of your personal interests. I know that at least one writer has talked about wanting to change. The standard is that the publication is always going to say, if we do end up in a legal battle over this, it's going to happen in our home state. More often than not, the publication is going to be in New York City, and they're going to say, this is going to be handled in New York City, and people kind of accept that as the norm. Now, this is in the realm of, it's very rare that this is going to come up. But what if what if you do end up in a legal battle with this company, and they're in New York City, and you're in Seattle or Florida? Who's better equipped to do some traveling? Who's got the funding for that?
Right.
The freelance writer, probably not. So you might want to say, hey, this is going to be handled in Florida or Washington. I mean, it's a small thing. It depends. The person who mentioned that to me was somebody that was only on really big articles, and that too. I mean, I think all of us would say we handle the contract differently if it's a little short news story versus if it's a large feature. Another good one that can much more often come into play is take a very close look at the kill fee. Now, number one,
good point.
There's the percentage. Simply going to be 25 or 50. Obviously, it's to your advantage to have that number be higher. But a much more important point, and this is another place where the language has drifted. You want to look at that clause. This is not legal advice. I would want to look at that clause and ask myself, does this give the publication the freedom to cancel my article even if there's nothing wrong with it? And that's the real problem. if I write an article and it's up to their standards and it does everything that I was contracted to do, that should not lead ever to a kill fee. That should lead to a full payment. If they decide my acceptable article is not going to be published for their own reasons because, of space or, who knows, there's a whole list of reasons that a story can die after you've written it properly, you need to get paid for full. You've done the full work. You've got to look at that language and make sure that the only way they can go to the kill fee clause is if you've done something wrong that's not easily fixed.
Right, that's a critical point. So pay attention to the wording in the contract related to the kill fee, and make sure that it's that you're in agreement with the reasons why a story can be killed. Yeah, no, that's great advice. Now, one other thing that actually it occurred to me when you were talking about jurisdictions is that we've heard a little bit in the news about libel laws, and that can sort of vary from country to country. And so, if you're writing for a publication that's in another country that has different libel laws than are in the United States, how do you what should you do when confronted with a contract where the language around the libel laws may be less than comforting?
Well, this is what we got at in the beginning. Is number one, it's very difficult for a freelancer to be up on the laws in a bunch of other countries, and all I'm aware of that you can do is kind of work in some of those more general protections, things around the language, like making sure that I'm only on the hook for legal fees if it's proven that I did something wrong, etc., etc. But the UK is the perfect example to keep in mind when you're looking at these things, because in the US, libel laws, and I'm certainly no expert, but in general, US libel laws are built around the concept that I have to write something that is incorrect about somebody that also damages them in some way before anybody's going to get any money from me or a publication for something I've written. In Britain, I don't know all the specifics, but in general, their libel laws, if you write something that's true, in some cases, if it damages a person in a certain way, even if it's absolutely true, they can still sue you and they can still win. So these are the kinds of things you want to have in mind when you're looking at those contracts. That there's a big world out there on the other end of the internet, and you got to be you need to try and protect yourself.
Right. So so wrapping up here in a few minutes, but kind of on the issue of power of community, I'm wondering, what kind of resources have you been able to find, or have others talked to you about, for writers who are in a contract dispute with a publication? What sort of advice or remedy, short of hiring a lawyer, might there be?
There have been, I can't list any specifics here because it has changed a lot, and I don't know what always the problems are that lead to that. Various writers' organizations have had sort of disputes type groups where you can come with a contract problem. Often it'll be, somebody not paying you and that kind of thing, but other legal issues. I don't know of any off the top of my head that are active right now. A couple of these things with writers' organizations have come and gone for various reasons. I mentioned earlier that I have gotten very helpful advice from the ASJA website, and as far as I can tell, a lot of that advice has been pulled down. I assume that these things are tied to legal challenges. I really don't know, but I guess this is not going to be especially helpful or satisfying as an answer, but the thing to do would be to start with the organizations that a writer might be a part of and ask around with the leadership there, do we have a contracts dispute group or a process there? And if that doesn't work, then you might have to move out and maybe even join another organization. And again, just tapping into the community is the best way to deal with some of these things. There have been issues through the NASW where, this happened to me. I had an issue where I probably should have taken legal action, and I didn't. It was early in my career, and I didn't know how much of it was my fault and how much was their fault. And I found out later that this publication had a pattern of doing some very bad things, and I was really sad that I didn't know that at the time. So community, asking around as much as you can is going to be the best place to start.
Okay, great. And just for viewers, ASJA is the American Society of Journalists and Authors, and NASW, National Association of Science Writers. There's the Society for Environmental Journalists. There are a number of different national organizations that may be equipped to help you in the event of a contract dispute, or even giving you some boilerplate language to consider instead of what's being offered to you in a contract. And as Mark has said, the publication may not always agree, but they will never agree to anything that you don't ask for. The most important thing is you have to know what to ask for it, and work with the editor of the publication and trying to get a better contract. So I want to thank Mark again for being our virtual mentor. We are going to take August off, but we are hopefully going to be back in September with more virtual mentoring. And again, this is coming to you from the co-authors of the Science Writers Handbook. And for more tips, you can always go to our site, which is pitchpublishprosper.com. So once again, thank you so much for tuning in, and we'll see you all in September.